anyone that's been involved in schemes of arrangement at all, to any degree, this decision was, frankly, very, very surprising. I mean, it was just out of the air. I mean, I think very welcome, obviously, by the US policyholders, but anyone that's dealt in this area, it was very surprising. Because what the judge said was, he said that, and I'm just, there's a quote here from the judgment. He said, the common thread is that a scheme is put forward in a situation where there's a problem requiring a solution. So what he's saying is, generally, schemes are put forward in a situation where there's a problem requiring a solution. And that's a situation in which creditor democracy applies. So what he's saying is, where there's a problem, 75% of creditors can cram down everyone else. Then he went on to say a solvent scheme, didn't say a solvent insurance scheme, he just said a solvent scheme is an instance of a case where creditor democracy should not carry the day. So what he's effectively saying there was, okay, notwithstanding we've had this procedure on the statutes for 300, 400 years, and notwithstanding no other cases required this, Lord Glennie today is saying, fine, creditors, 75% vote cannot cram down everyone else. You have to find something else. There has to be a problem. And solvent schemes just don't cut it. He then went on to say that solvent scheme, however, because part of the other challenge was, well, is a solvent scheme actually an arrangement or compromise? Is there some give and take here? And into that he said, no, yes, it is an arrangement. It's definitely an arrangement within the statute. It's just that I need this, effectively, I need this extra element to be able to sanction this solvent scheme. And that was a very, very surprising decision. Now, on the appeal, Scottish Lion, as I said, appealed the second issue, didn't appeal the first issue. And there we've got basically a real high-level summary of what Scottish Lion argued and what the US policyholders were arguing. And in some instances, actually, they're sort of saying slightly different things, actually. Scottish Lion said, you know, yes, the judges said, although the scheme was an arrangement within the statute, Lord Glennie is requiring something more, a problem, to permit the 75% cram down. But having gone through the statute, the history of the statute, the case law, there's nothing that distinguishes solvent and insolvent schemes or creditor or member schemes. I mean, let's not forget that schemes of arrangement under the Companies Act can apply not only to creditors and not only to the insurance industry, but they're a very, very widely used tool, and they can apply for shareholder in the context of takeovers, M&A, and shareholders to deal with shareholder disputes and to affect takeovers. So, in Lord Glennie saying for a solvent scheme needs to find a problem, the ruling would have significant implications for the usage of schemes in a solvent context in and outside the insurance industry. I mean, the problem was, well, the problem was we couldn't define, we on the Scottish Lion side couldn't decide, well, you know, what do you mean by a problem? What's a problem? How much is a problem? Insolvent companies, fine, there's a problem. A company that's troubled, fine. But then if you get a company that has, you know, some issues with its solvency, how much of a problem is that? And then what about shareholder schemes, takeovers? There's no problem there. What about restructurings where you have several layers of debt and the junior debt is saying, well, hold on, there's no problem here because therefore there doesn't need to be a restructuring because the value is going to return to this company and therefore you don't need to haircut my debt. I mean, it would have manifold implications throughout the whole of the uses of schemes, not just for insurance and not just schemes. What was interesting, though, is that, and it's an important point, this was a ruling on a specific legal issue. This was not the sanction hearing. This was not a ruling on fairness, said Scottish Lion. And Lord Glennie himself had said, this is a preliminary part of the sanction hearing. This is not, and therefore we took that to mean this is not the hearing itself. Now, on the other hand, on the other side, the US policyholders were really focusing mainly on fairness. They were saying, effectively, I think what they were saying, and Ben, you know, can chime in, the court must be satisfied the scheme is fair and reasonable. And effectively, what Lord Glennie's saying here is, it's not fair and reasonable. This requirement for a problem is really the judge saying, I don't think the scheme's fair. Now, to that, and therefore there was some debate over, well, was Lord Glennie's hearing really a fairness hearing, or was it really a hearing on preliminary issues? Now, we thought it was a hearing on preliminary issues. there'd be no evidence on actuarials, there'd be no evidence on the estimation methodology. That would all come later. What was interesting, though, was that in the submissions, in the US policyholder submissions, even they said that they weren't, that they did agree with Scottish Lion's problem requirement assertions. They were saying, well, this is a hearing on fairness. We don't. What I imagine they were, what I think they were saying was, we don't think there needs to be a problem per se to be found as a matter of jurisdiction for the court to sanction a scheme. This is really an issue on fairness. So Scottish Lion and the policyholders were slightly at odds in some ways as to what was actually being argued. So to summarise, Scottish Lion were taking the view this was a legal issue. This was an issue as to what were the requirements to sanction a scheme as a preliminary legal issue on principle, whereas the policyholders themselves were really attacking it on the basis of fairness. And Scottish Lion was saying, well, look, that's really an issue for the sanction hearing, and this ain't it. The sanction hearing, if we get past this stage, then we can deal with it. In terms of what conclusions can be drawn, well, I think it's a bit too early yet. The Court of Session's Inner House has yet to rule. I was told that, we thought they would rule during January. I have been told that their lordships have been involved in deciding cases, quite serious cases in Scotland in relation to paedophilia and tax. They involved their lordships, but as judges. I was pleased to hear. But that may be the factor that's actually delayed the result. Obviously, if Scottish Lion succeeds in their arguments, then the debate will simply move to fairness at the sanction hearing in a traditional way. If the policyholders succeed, well, the impact there will really depend upon what the reasons were behind the ruling. But I would say that if the decision of Lord Glennie is now to stand, that's going to have a ripple effect outside of insurance and throughout restructurings.